Hi, I'm Jill Headford, Head of Litigation at Tozers. Today I'd like to talk to you about easements. Well, essentially they're rights over land for the benefit of other land. Familiar examples are rights of way, rights to lay pipes and cables for supply of services, rights of support. Disputes are often about the scope of an easement. What does it actually entitle you to do? If the right was granted in a deed, the scope of it will depend on the actual words used. They may be very wide, for example, a right of way at all times and for all purposes with or without vehicles or animals. Or they might be restrictive, for example, a right to access a single dwelling. And the words themselves will be open to interpretation. Does for all purposes mean all purposes for which the land was being used at the time of the grant, or will it include future purposes? And what about intensity of use? Say at the time of the grant there was just one house on the land, can the landowner use the same right of way to access a development of 10 houses or 50 houses? Well, the court might grant an injunction that the interference must cease. Sometimes the court will refuse that because of delay or acquiescence and award financial compensation instead. But rushing to court may not be the best way to resolve things, and there will be risk. There'll be a winner and a loser, and the loser will generally have to pay all the costs. Certainly, a constructive approach, perhaps mediation, can save you time and money. We can advise you on the best way forward, bearing in mind all the circumstances and your priorities.